And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels.
This one hits hard. We're in a Texas courtroom where Marlon Daniels, a military veteran, is being sentenced for a deadly drunk driving crash. He doesn't make excuses, he owns it. Judge Boyd speaks with compassion but stays firm. Nobody plans to drive drunk, but it still happens. Daniels took a plea deal. 18 years in prison, no appeal. It's a sad mix of regret, service, and tragedy. By the end, Judge Boyd reminds everyone that even good people can make terrible mistakes.
Court is calling 2024 CR 009218 and 2024 009219, State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
And for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say, my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years.
18 years might sound tough, but it's what came from the plea deal. By pleading guilty, Daniel skipped a jury trial but gave up his right to appeal. That's the trade-off. Judge Boyd points out how unpredictable juries can be. They might have gone easier or much harder. Daniels chose not to take that risk. His decision shows remorse, not denial. And when the judge says intention doesn't erase impact, it hits deep. One moment of thinking you're fine to drive can destroy everything.
Knowing that by taking these 18 years, there is no appeal because you waived your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, And cause number 2024 CR 009218. The court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This will run concurrent with 2024 CR 009218.
Quick moment of courtroom precision. Daniel's lawyer steps in to correct the record. 1 combat tour, not 2. It might seem minor, but in sentencing, details like that can matter. They affect classification, prison programs, even parole. Judge Boyd listens, notes the correction, and keeps things moving. Calm, fair, focused. What do you think? Should his military service have earned him a lighter sentence? Let me know in the comments.
There is to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have the combat ribbon. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors of misdemeanors. There was only 1. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you. Is there anything else from either side?
Well, Judge, I don't know if Mr. Sherman wanted to bring this to your attention, but because the defendant is going to be in custody, I did see that he filed motions to remove the ignition and the lock. Your motions to.
Yes, she's already signed.
Okay,
Yes, I signed those,
no
yes.
objection to that.
All right, thank you.
Judge Boyd makes it official. 18 years, a $2,000 fine, $60 restitution, and a deadly weapon finding. Meaning the car was legally treated as a weapon. Sentences run concurrently, and that's it. A soldier who once served his country now serves time for one tragic mistake. Painful but fair. If this case hit you like it did us, tap like, share, and subscribe for more real courtroom moments. Was justice served, or should mercy have weighed more?
Sure. All right, so here's the thing. You got to save the tears because we're here on a motion to revoke because the state is alleging that there are some actions that you did that were a violation of your conditions. Do you understand?
Today, We're in Judge Boyd's courtroom for State versus Joshua Jacob Cannon, a 20-year-old facing a motion to revoke probation for aggravated robbery. Cannon was given a second chance through deferred adjudication, but he's back, accused of violating probation by using marijuana. This isn't just another hearing. It's a life-changing moment. Judge Boyd doesn't sugarcoat it. Save the tears. Tough, but fair. Cannon's choices could mean freedom or life in prison. This case is about accountability versus addiction, second chances versus self-destruction. Watch closely as Judge Boyd pushes him to decide. Does he want rehabilitation or incarceration?
All right, so are you all proceeding on the motion to revoke?
We made the recommendation that MRT, this is to go forward. Yes, that's the MRT and the ILP.
All right, the court is calling 2023 CR 2570B State versus Joshua Jacob Cannon. Can I have parties announced for the record?
Jason, Your Honor.
Mark Lifford, fence judge.
And are you Joshua Jacob Cannon?
Sure.
All right, so here's the thing. You got to save the tears because we're here on a motion to revoke because the state is alleging that there are some actions that you did that were a violation of your conditions. Do you understand? All right. So are you the same Joshua Jacob Cannon who was placed on deferred adjudication in 2023 CR 2570B for the offense of aggravated robbery on June 12, 2023 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. And we're proceeding with a number two, that is the second to last number two.
Okay.
It is a violation of condition number two on or about the 16th day of August 2024. Bear County says the defendant Joshua Jacob Cannon admitted there commit to the illegal use of controlled substance, namely marijuana, violation of condition number two.
How do you plead to that, true or not true?
True.
Waiver of any violating condition.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number two, the court could find it true, grant the motion, find you guilty, and sentence you to life in prison?
Yes, sir.
Do you understand if you have some sort of an agreement that you've worked out with the state, I don't have to follow that. Once you've pled true, I can sentence you to life in prison. Do you understand that?
I understand.
Knowing that you still wish to plead true to violation of condition number two?
Yes.
Court is finding violation of condition number two true. Is there a proposed agreement?
There is, Your Honor. It is denied a motion to adjudicate, continue the individual on the deferred with the amendments to add MRT course and intensive outpatient treatment.
All right, is that the proposed agreement?
It is, Your Honor.
All right, let me ask you something. Do you want to go to prison?
No, ma'am.
Then why are you doing this?
When Judge Boyd asks, "Do you want to go to prison?" she's not being dramatic. She's being real. Judges see this every day. Young defendants saying they don't want prison, yet making choices that lead them straight there. Cannon admits he's only been to 2 weeks of NA meetings, even though he's been on probation for nearly a year. That's a red flag. Judge Boyd isn't buying excuses. She's giving a reality check that effort matters more than words. It's tough love, but it's meant to wake him up. And the real question she's asking isn't about prison. It's, do you actually want to change? What do you think? Is this the wake-up call he needs or too harsh for a 20-year-old?
I make bad decisions.
No, I mean, here's the thing. You have decisions that you have to make. And on the one hand, your decision is, do I want to do this? If I do this and I'm caught, I can look at life in prison. And then what ends up happening is your attorney has and this is where I've been a defense attorney before. This is where the attorneys are throwing themselves on the mercy of the court saying, please let this judge follow our agreement, even though I don't have to do it. So when you're making decisions and knowing you could go to prison and you're still choosing to do this nonsense.
I've been going to NA meetings. I've been going there for 2 weeks.
Mhm.
So I've been trying to.
Well, but see, here's the thing. You've been on probation since 2023 and you only have two weeks. What have you been doing with your life? Do you have employment?
Yes.
What do you do?
I work for Hill Country Waste Solutions. I've worked 60 hours every week.
Mm-hmm. But you find time to do this. So, I mean, I will tell you, and your attorney will tell you, and Mr. Garaham will tell you. How old are you?
20.
You're 20. Do you know how many 20-year-olds are at the prison? A lot. And if you don't want to get your life in order, you know what's going to end up happening? You're going to be at the prison. I will still remember you because I remember all the people who come through here. But you know what everybody's going to say? Oh, well. And this is what I can tell you about the government. The government may not have money to build state hospitals, but they will always find money for the prisons. And whether or not there's supposed to be 5 people in the cell or 2 people in the cell, they will put 5 people in that cell. They will put 6 people in that cell because they're not going to let you just be out here and say, oh, well, you know, it's overcrowded, so we don't have another jail, so we'll just let him be out here. That's not the way it works. And he can tell you that's not the way it works. And if you're drug tested today, are you going to be positive? You need to tell the truth and shame the devil. What are you going to be positive for?
This is the moment where most defendants dig their own grave, honesty without action. Cannon admits he used marijuana while on probation. And while it might be legal in some states, it's completely banned under probation rules. Judge Boyd reminds him, no alcohol, no weed, not even at home. When you're on probation, freedom comes with conditions, break them, and you're showing you'd rather be in prison than rebuild your life. The judge gives him 2 options. Take treatment seriously or serve 5 years behind bars. It's that simple. Probation isn't punishment. It's a test.
Marijuana. Yeah.
So here's the thing. I know people say marijuana is not a big thing, but when you're on probation, guess what? And your attorney will tell you this. You're not even allowed to drink alcohol in your house.
Yes, ma'am.
So you're not even allowed to smoke marijuana in your house. If you do, you know what that's telling me? You want to go to prison. So I'm going to give you a decision. And what I can tell you is, you know yourself better than your attorney does, better than I do, better than probation, better than the state does. So I want you to look deep inside yourself and discover and realize whether or not you can complete this probation or not, because you signed up for probation to be on probation for 10 years. So that's 2033. If you cannot complete this probation and you know you cannot complete this probation, just let us know. I will sentence you to 5 years in the prison. Otherwise, I will follow this agreement that you've reached. They're going to give you UAs and they're going to test for levels. If those levels go up, that signifies that you're using, and a motion to revoke is going to be filed, and we're going to be right back here. So those are your only 2 choices. I'll give you the MRT, the intensive outpatient treatment. I'm going to make you do NA meetings, and they're going to test for levels, or you can call it a day, and I'll sentence you to 5 years in the prison. Which do you prefer?
TR meetings.
All right. Have you had a time to internalize that?
Yes, ma'am.
All right. Because I will tell you, the state will tell you, I've sent 20-year-olds to prison before.
And Judge, I know he's very emotional right now, but when I've talked with him, he has conveyed he needs help. I mean, he has been self-medicating. He got in a real bad accident about 1.5 years ago, jacked up his hip, no excuse, but he needs help to figure out not doing that. I mean, he takes full responsibility, Judge.
All right, probation. I'll deny the and I'm sorry, probation. Are you recommending this as well?
Yes, Judge.
All right, the court will deny the motion, alternate amending conditions to include the MRT, IOP, and I'm going to want UAs, test him for levels. And he's going to do sober support meetings. In 30 days. And your levels should start going down. Do you understand? Is there anything else you need from the court to be successful?
No.
Judge Austin, do you want me to put that as UA?
How often are you, because it's marijuana in his system?
Every 2 weeks.
All right, so there's going to be UA every 2 weeks until he presents with a negative UA. Is there anything else you need from the court to be successful? All right, we can go off the record. Here's the thing. Everything that you do from here on out, I'm gonna help you with your decision making. If your actions could result in you being revoked and going to prison, you shouldn't do it. If your actions are like, maybe this is something I can get revoked for, maybe not, you shouldn't do it. Do you understand? Because otherwise, you're going to be at the prison, and either you are, well, first, a motion to revoke will be filed. Either you're going to make bond or you're not. If you don't make bond, we'll bring you over dressed in orange. We'll hear it. And either you're going to get revoked or not. And either you'll end up in prison or not. Do you understand?
Yes, sir.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
By the end, Judge Boyd makes her decision. She denies the motion to revoke, giving Cannon one final chance. He'll go through MRT counseling, outpatient treatment, and biweekly drug tests until he's clean. This is justice finding the balance between accountability and compassion. The judge sees potential in him, but also lays down a warning. One more mistake, and it's prison. At just 20 years old, Cannon's story could still go either way, redemption or ruin. If this case pulled you in like it did us, hit like, share your thoughts in the comments, and subscribe for more real courtroom moments that show what justice really looks like.